The record shall show that the jury is seated in the courtroom. All parties are present. Good morning to all of you, ladies and gentlemen. Another weekend that whizzed by, didn't it? It seemed like a blink of an eye. Thank you for your patience and thank you for your citizenship. And I believe Mr. Raymond was on the witness stand. The state may proceed with your questioning.
Thank you, Judge. Go ahead and restate your name for the record.
First name's Christopher, last name's Raymer.
And you're the same Christopher Raymer that was testifying Friday in this case, correct?
Yes.
And just by way of kind of bringing everybody's memory back to where the testimony was Friday, you're here to testify about a burglary report, is that correct?
Yes.
And remind the jury how a burglary report is generated.
Vehicles have infotainment systems. Those systems can record phone data, GPS data, things of that nature. I, as a certified burglar operator, can extract that information from the vehicle and then generate reports that can show different things such as track logs, where the vehicle's been, and at the time that vehicle's been there, calls, messages, things of that.
I believe you told the jury on Friday that this information came from potentially 3 different Bluetooth connected devices.
Yes, sir.
Remind them what those were.
The first one was Chels. Second one was Cody MF, and the last one was labeled just iPhone.
And you used that information to generate a report, correct?
Yes.
Yeah, approach check.
Yes.
Show you again what's marked the state's exhibit 54 is that 3-page report that what you generated from the information obtained.
Yes, sir.
You know, we would tender states 54 based on the testimony and the hearing that was elicited from the afternoon.
Go ahead.
For the record, Judge, for the record, I withdraw my objection, but to that.
All right. The objection is overruled. State's Exhibit 54 is admitted based upon the hearing and the conclusions of law and the decision of this court. It is made part of the record, and the state may proceed.
Thank you, Judge. So I'm going to put this up on the overhead, but before I do, just kind of to help the jury, the first column they're going to see is what again?
Is the longitude and latitude, the GPS coordinates of the timestamps of the vehicle's location.
And the second row?
It's going to be a pinpoint on a map location of those GPS coordinates.
And the third?
Is the timestamp of when that vehicle reported those GPS.
And I believe you explained to them on Friday that you transferred, the only thing that you adjusted was the time frame from UTC to Central Standard Time?
Yes, sir. So UTC is Universal Time Coordinated. Common Language is Universal Standard Time. You can then change that to match where you are, so you can read the report in the time in where you live.
This report starts with what date, sir?
3/26 of 2022.
And again, by way of refresher, you were asked to just look at a certain time frame.
Yes, sir.
Can
When
you remind the jury what that time frame was?
that time frame from Detective saying told me was 12 on the 26th to 9 on the 27th.
And that is in the year 2022.
2022.
All right, so what are we looking at here? Just by way of example on this first entry. What's the column, this first column?
That first column is going to be the longitude and latitude of where that vehicle GPS coordinates hit at 12:19 p.m. on that above date, the 3/26/22.
Also, did you explained to me this morning as to how that's acquired?
Yes.
And I don't remember us talking about that Friday.
Right.
You said something about 4 satellites.
Yes, sir.
Can you explain that to the jury?
For these vehicles, the way they work to get the GPS coordinate, there's thousands and thousands of satellites orbiting Earth. GPS satellites require 4 to get these coordinates to connect to a vehicle and get a timestamp on them. So to get that coordinate, the vehicle will send a signal to the satellites. The satellites will then send a signal back to the vehicle. And knowing how fast the vehicle is traveling, they can pinpoint where that vehicle is. So to get that timestamp, it's from 4 different satellites to make that timestamp.
So is it fair to say from these first couple of entries that at the time in which you're looking at, this car is located somewhere on Crystal Beach as you begin your information download here, correct?
Yes, sir.
And it begins to move locations.
Yes, sir.
Looks like it passes through Rollover Pass,
Yes, sir.
starts to travel towards Winnie.
Yes, sir.
Still traveling at about what time, sir?
That's a 1:42 in the afternoon.
And then ultimately lands, what's this entry here say?
Cobb's Corner near Cody Arnold's house.
Did anybody tell you that that was a location of interest for law enforcement?
So that was, the suspect information was provided to me by Jefferson County's, lead detective Chad Williams.
Right, so you knew we were interested in this particular address, right?
Yes, sir.
And it's fair to say that in your report here, this is the first time you see on the 26th that he's at that location.
Yes, sir.
Does he stay there for a period of time?
Yes, sir. Appears he stays there for several hours.
I actually paused my paperwork there, right at the bottom of page 1. Do you indicate by your information that he leaves at around 3:36?
Yes, sir. By leaving, it shows action of that vehicle leaving that particular course.
Brings us to page 2 of your report. Looks like it takes Cragen Road down to Highway 124,
Yes, sir.
then to Hampshire and ultimately to Winnie, right?
Yes, sir.
Where did they end up at about 4 o'clock?
Appears they were in a McDonald's parking lot at that.
And do they go basically from there and head towards an RV park?
Yes, sir. Near 140.
Do you know the name of that RV park?
I do not know, sir.
Haven't heard of Redneck Riviera, have you?
No, sir.
Does it appear that they stay there up until about almost 6 o'clock?
Yes, sir.
So testimony was that they were at that location from 4:30 to 6. That seems to track, right?
Yes.
All right, so right above that, there's an entry you put, time is missing.
Yes.
I want you to explain what that means for the purposes of the jury when we've got missing times.
When these vehicles send a signal, to gain an accurate signal, it has to have 4. So if, let's say 3 satellites send a signal and the 4th one doesn't, it'll stop that time until the next time step comes up that the vehicle then gets all 4 signals. So if there's a time missing, we allot that time, as if the satellite's not sending it or the car not receiving it.
Did that happen because you're missing one of the 4 satellites?
Most likely. And things cause that, high buildings, trees, particular weather, something of that nature.
Does it appear the car leaves there sometime, leaves from the trailer park and starts to move, correct?
Yes,
Where's it headed back to?
yeah, it looks like it goes back to Hampshire, according to the coordinates.
All right, so I see here that you put an entry at Stony Arsenos.
Yes, sir. I was provided the same type of information as the victim's information about the detective, so we knew where the victim's location was.
Was that a location on County Line Road?
Yes,
Oh, look, that's right there, behind the next one. So can we read from these two things that it was at that location for about 20 minutes?
Yes, sir.
Apparently leaves there and heads back to Cody Arnold's house, correct?
Yes, sir.
That's about 7 o'clock again on March 26th. Right?
Yes, sir.
How long is it there? Oh. 16, 17 minutes, maybe?
Maybe, yes, sir.
Then goes back to Stoney's house.
Right.
That's its entry here, right?
Yes, sir.
Then you've got some missing time. And then you explain that, but we got about an hour and 15-minute, hour and 20-minute gap. But your next entry, are they right back at that location?
Yes, sir.
End up leaving there, and where's the next place that they go?
So they leave Stoney's house and they arrive at Cody Smith's house.
So if the jury heard from Cody Smith that someone was at his residence for about 15 minutes talking with him, that would track with this information here, yes?
Yes, sir.
For here, you actually have that from 8:45 to 8:57, correct?
Yes, sir.
Then back to Stoney's house, right?
Yes, sir.
Then more missing time.
Yes, sir.
Then we get to the next day. That's what this entry is right here, yeah?
Yes, sir. 27.
And where is that car at basically 7:45 in the morning?
It's at Stoney's.
Goes from there to Brandy Moon's house, correct?
Yes, sir.
Was it there, that time frame from 7:54 to 8:28? Or is that just the next place you locate?
The next place that the timestamp was located was at that Sexton.
All right, so where do we? I think they go from there to. You marked it here as Chelsea Trailer Park.
Yes, sir. Chelsea Chick was also identified to me as a suspect, and her location was also provided to me.
Am I right that that's somewhere on Crystal Beach?
Yes, sir.
Like they're there, really just there and gone,
Yes, sir.
and then on to some storage village,
That's cool.
and that's the last you have, correct?
Yes, sir. Due to the allotted time was provided.
Right. You only provided the time, dates and times that you were asked to look
Yes,
at,
sir.
right? So for example, you can't say where this car was based on your report before noon on March 26th.
Right.
You only looked at this short time frame, yes?
Yes.
Let's talk about the accuracy of this report. Has it ever been shown that this information is not accurate?
Not in most cases.
And I don't remember, just because it's been since Friday. I want to go over the training that's involved with this. How many hours did you tell the jury it takes to be able to learn to do this?
So we do a 40-hour course, 5 days, 8 hours days, after which we take several tests. We have to physically show them on different infotainment systems that we can correctly identify all this type of information.
And in that training, did they vouch for the credibility of this information?
Yes, sir.
Is it primarily driven by the need to come from 4 different satellites, for
Yes.
example? Instead of 2.
Right. And even in the class, they provided us information from the United States government that states upon their accuracy of GPS locations, that the level of inaccuracy is only from 0 to 2.3 feet of accuracy. So within a particular tag location that GPS coordinates come up, the margin of error is from 0 to 2.3 feet.
Is that why you can give this amount of numbers by way of example on that second entry on 54?
Yes, sir.
I mean, out to those numbers,
Right.
it almost looks like you're giving me the actual numbers for pi.
Yes.
This goes on forever, right? So that's the level of accuracy, correct?
Yes, sir.
That's what.
Good morning.
Good morning, sir.
Are you surprised that you're relying upon the government for anything that's accurate? Just a couple questions since I've taken. This is based on vehicle location, right?
Yes, sir.
And they use 4 satellites of coordinates in order then to determine where the vehicle is.
Right. The vehicle will send a signal to the GPS satellites.
So when you testify that the vehicle was in Winnie or it's in Hampshire or was down at the beach, it's the vehicle that was there.
Yes.
Nothing further. That's what it's true.
Nothing further, this witness, Judge,
Sir, you are excused. Thank you.
Thank you.
Next witness, please.
State of Texas rests.
State rests. What says the defense?
I have a matter to be taken outside.
The record shall show the jury has exited the courtroom. All parties are present. Go ahead, Mr. Burbank.
Please support at this time, Your Honor, based on the state's resting its case in chief. Defense now makes an oral motion of instructed verdict or acquittal based on the state's failure to prove the elements in this indictment beyond a reasonable doubt and to allow this case to go further to the jury for a decision. Mr. Arnold is, as the court is well aware, is charged with the offense of murder. It alleged that he shot the complainant with a deadly weapon, a firearm. That has not been proven to that level of beyond a reasonable doubt. Further, we will submit to the court that even if there was possibly an agreement, there was insufficient evidence in reference to be submitted to the jury either as a party or a plan or common scheme in the death of Ms. Stone. So we ask, Judge, that you grant our motion of acquittal or not guilty at this time.
Response, please stay.
As Your Honor knows, the theory has been from the beginning that this is a party accusation here, not that Mr. Arnold actually pulled the trigger. Disagree with Mr. Burbank. There's multiple witnesses who have provided evidence for the jury to consider as to his manner and means in which he's aided, promoted, assisted, and acted as a party to this offense. We feel that it's more than sufficient evidence to go to the jury.
Okay. Did you want to articulate into the record some of the evidentiary matters that have been proven that connect the defendant?
The point, the obvious answers as to jury on that, Judge, is starts with Mr. Eiley, who the jury was the second witness the jury heard from, where Cody clearly asked him for help to get rid of Caitlin. That is, anytime you're assisting with getting rid of the body, it is aiding and assisting in the commission of murder. So the evidence starts compiling at that stage. When you backtrack, when you look at the statements that he made to Mr. Powell, where he starts out lying about where it is that she is, he's already covering up for his involvement in the crime right from the very beginning of the first statements that he makes. We learn from additional witnesses through the 80324 evidence that he made a plan with Chelsea Shipp. We learned that from Brandy Moon that Cody asked her, Chelsea Shipp, to take care of a problem. That was the statement that was entered there. And the second half of what he's supposed to do is he's supposed to get rid of the body. That's where we get the initial opening concept about some discussion and plan. We learn additionally from Cody Smith that Shipp tells him specifically that they had a plan, that it started days before. And he gives us the motive that it's not necessary, but he tells us then that Chelsea Shipp talks about Caitlin being pregnant and the reaction, that how much trouble he was going to get into, and that they talked about that to try to get past that. Then we get down to the statements of Mr. Arnold's says himself. He admitted in the first interview that he says about what he did, and then he changes that answer. Then we get to the second interview where he again admits to talking to Eileen about getting rid of the body, uses some colorful language saying he's going to get rid of the shit. He then lists her as one of those items that he classified that way. Judge, all that is more than sufficient evidence for a jury to consider about his role in this offense and how he aided, assisted, commission of this offense. They can make reasonable inferences about him soliciting and encouraging her actions, that it was done in his direction, that he definitely aided and or attempted to aid her in the commission of the offense.
Right. Any
No.
The defendant's request and motion for instructed verdict is denied and overruled.
I have another matter, Your Honor.
Go ahead.
At this time, I'd like to call Mr. Arnold. Stand up, please, go ahead.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing we are about to have? It's going to be concerning, I'm sure, your decision as to whether you're going to testify as a witness in this trial. Do you solemnly swear or affirm any statements you make during this hearing with your attorney that's on the record is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Lower your hand. Go ahead.
Mayor, police court.
Yes, sir.
Your name is Cody Arnold, correct? Yes, sir. And of course, you are the defendant in this cause of action, correct? Yes, sir. You've heard now all the evidence that was presented to the state and they arrested. You understand that? Yes, sir. It is our turn now to present evidence in your case if we wish to do so. Understand that? Yes, sir. One of the things that take into consideration is that we do not have to present anything. We don't have to present these witnesses or evidence in this case. In fact, the judge is going to instruct the jury that they cannot consider your silence or lack of any type of calling witnesses or anything like that. You understand that? You also have some constitutional rights. You do have an absolute right, you understand, to remain silent. And that's a protected right in which the judge will instruct the jury again that they may not consider your silence in deliberation. Understand that? But on the same context, you have an absolute right to take that stand and testify, and me to ask you questions, you to answer them, and then once I stop, then the state's going to have the opportunity to cross-examine you and ask you questions also that they feel are relevant. You understand that? Yes, sir. We have talked about this over the last almost 4 years, correct? Back and forth. And even this morning, we talked about this, we're going to need to make a decision, correct? Because have you made a decision whether or not you'd like to testify or not on your behalf, or would you like to remain silent? Remain silent. So when you make that choice of remain silent, are you making that freely and voluntarily? Because there have been no threats or promises that were made to you, correct? You're doing that and you're with your conversation with counsel. That's me, correct? Right. And this decision you've thought about for a long time, correct? So, and this is what you want to do. Yes, sir. I have nothing further, Judge.
All right. Anything else from the defense?
No,
All right, you may be seated. All right, the state has rested. Is the defense going to present anything?
we rest.
You rest. All right. Okay. What's going to have to happen is we've got draw some conclusions on the proposed jury charge that the court had prepared. And we're going to have to make sure that the parties have thoroughly reviewed that. Until that happens, we're going to be in recess. I'm going to ask the bailiff to tell the jury we're going to need some time here, and we'll keep updating them. They can relax, stretch their legs, but it may be a little while until all of this can get completed, and then we can move on to final arguments of the lawyers and the jury to recess for their deliberation. We are in recess. Thank you. And cause number 22-40127, the state of Texas versus Cody Lee Arnold, who is present with his attorney, Mr. Burbank, and the state's attorneys. The court understands that the parties are going to rest the presentation of the evidence in their cases. So during this break, the court has tendered a proposed jury charge to the parties. Have the parties had an opportunity to review the proposed jury charge? Are there any corrections or changes to it? State of Texas.
Back in the session.
Defense.
Yes, Your Honor.
Go ahead.
I have part of it. Police court.
Yes, sir.
This court is well aware the jury charge has included in it numerous instructions, but definitions. It goes to motor, firearm, intentionally, knowingly. There is bodily injury, things like that. And also included in it is parties to an offense. In the application, part of it, of the charge itself, it states that the complainant, either individually or as a party to this offense, as the term party is described in those jury instructions. Defense objects to the wording of as the term party is described in these jury instructions. Basis of the objection is that defense feels that you're giving more weight or more credence to that definition over and above all the other definitions that are outlined in this jury charge. Defense would ask the court to consider that as we went through the death of an individual, namely Caitlin Nicole Stone, hereafter style the complainant either individually or as a party to this offense, period. And then goes on to by shoot or comma by shooting the complainant. That is our objection to this charge.
Right. State.
Judge, during the break, I looked at some other application paragraphs that from pattern jury charge and all, and the way the court has fashioned it here, I've seen the court do before. It's in compliance with the pattern jury charges. And the other application paragraphs I've seen actually go into more detail about reiterating the instructions. Those that have been approved are a little bit more intrusive than what the defense is objecting to here. So the state agrees with the court's draft, and then it has the minimal effect, and yet it instructs the jury that what's been the state's theory from the beginning, that this man is a party to the offense, and we find it just and proper.
All right. The objection by the defense is noted. It is overruled. The court has used this charge in numerous of its over 600 jury trials, numerous times, and the term party has a definition under the penal code that is distinct from what is universally understood and used in common parlance by people referring to a party to an event. And because that term is unique in its usage under law, it has a special definition, and the court's charge is to ensure that the jury does not use a definition that they believe is appropriate or they believe is the proper one to use, which may be and is probably distinct under the penal code in its definition than what is universally understood by novice persons who are not experienced under legal definitions. And this is in actually is I think more helpful to the defendant because the party definition restricts the definition to a narrow focused definition, which rather than a global definition. So I believe that it's more helpful to the defendant to ensure that they use and in their deliberations the term party as instructed in the jury instructions rather than what the jurors may understand that term to be in their normal everyday life, which is generally distinct from the definition from the penal code of party. So overruled. And anything else?
That would be better.
All right. And then please bring the jury in and we will. And the record shall show that the jury is present in the courtroom. All parties are present. And again, thank you, ladies and gentlemen, for your patience. When we broke last for this recess, the state had rested its case in chief. And does the defense wish to present any evidence at this time?
Your Honor, at this time, defense rests.
So, ladies and gentlemen, all parties have rested. The evidence is before you. At this time, I'm going to read to you the jury charge, which contains the law applicable in this case for your deliberations. In continuing to discharge your responsibilities as jurors, you must continue to follow and observe all the instructions previously given to you. These instructions are given to you because your conduct is subject to review, the same as that of the witnesses, parties, attorneys, and myself. Please listen carefully, as I know you will, and when I read the charge to you. After the lawyers make their concluding arguments and you go to deliberate, I will pass the jury charge to the bailiff and he will tender it to you and you can review it and refer to as necessary during your deliberations. Members of the jury, the defendant stands charged by indictment with the offense of murder, alleged to have been committed in Jefferson County, Texas, on or about March 26, 2022. The defendant has entered a plea of not guilty to this indictment. Our law requires that I submit the following charge to you in this case. This charge contains all of the law necessary for you to, which enables you to reach a verdict. If any evidence was presented to raise an issue, the law on that issue must be provided for you. Definitions. So that you can better understand some of the words and terms used in the charge, the law provides the following definitions. Murder. A person commits the offense of murder if he intentionally or knowingly causes the death of an individual. Intentionally. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. Knowingly. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Deadly weapon. Deadly weapon means one, a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury. Or two, anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using energy generated by an explosion or burning substance, or any device readily convertible to that use. Bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Parties to an offense. A person is criminally responsible as a party to an offense if the offense is committed by his own conduct or by the conduct of another for which he is criminally responsible, or both. Each party to an offense may be charged with and convicted of the commission of the offense. A person is criminally responsible for an offense committed by the conduct of another if acting with intent to promote or assist the commission of the offense, he solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense. Mere presence of the defendant at the scene of a crime is not enough, but it is a circumstance that, combined with other facts, may show that the defendant was a participant. Defendant's election not to testify. Our law provides that a defendant may testify in his own behalf if he elects to do so, and this is a right given to a defendant. And in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer to or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. Charge. Now, if you believe from the evidence beyond a reasonable doubt that in Jefferson County, Texas, on or about March 26, 2022, the defendant Cody Lee Arnold did then and there intentionally or knowingly cause the death of an individual, namely Caitlin Nicole Stone, hereafter styled the complainant, either individually or as a party to this offense, as the term party is described in these jury instructions, by shooting the complainant with a deadly weapon, to wit, namely a firearm, you shall find the defendant guilty of the offense of murder, unless you so find, or if you have a reasonable doubt thereof, you shall find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. You have a right to consider all of the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and the duty to determine what the facts are in this case. And in evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You must not consider facts that have not been introduced into evidence or legal principles not contained in the charge. It is improper for any juror to discuss or consider anything which they know or have learned outside of the testimony presented to you and the law contained in this charge. If a juror should discover that they have any outside information, they must not mention this information to any other juror nor consider it themselves in arriving at a verdict. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. And you must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Now, you cannot question the bailiff concerning the testimony of the law during your deliberations, nor should you discuss the case in his presence. If any question about the law develops during your deliberation, it must be reduced to writing and signed by your foreperson and then given to the bailiff. That question will then be answered to the court as soon as possible to the extent allowed by the law. There were exhibits admitted into evidence. Any physical exhibits admitted into evidence will be furnished to you for your review by the bailiff upon your request. After the attorneys present their arguments to you, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during your evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision or decisions, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case in accordance with the law and the evidence. There are two verdict forms, ladies and gentlemen. One, we, the jury, find the defendant guilty of the offense of murder as charged in the indictment, a place for the foreperson to sign. And the other option, we, the jury, find the defendant not guilty of the offense of murder as charged in the indictment. Place for the foreperson to sign. Under the rules, the state of Texas may open and close final arguments. What says the state?
Your Honor, I will waive my right to open, reserve the right to close.
All right, Mr. Burbank, on behalf of the defense, you may proceed when you are ready.
Police court,
Yes, sir.
counselors. This morning was kind of short. After all the last week of sitting around waiting back and forth. Doing this since 1990, 36 years. It's never easy when, especially when you do a murder trial and someone or been assaulted. It's never easy to get up in front of people and argue for a point. In this case, it is just as extremely difficult. Not that I have a problem representing Cody, but that there was a young lady that is not with us anymore, Caitlin Stone. And as you look at the totality of all the circumstances, you look, and especially this past weekend when I was out mowing the yard, and it just, what a waste. What a waste of someone's actions. And someone doesn't have the possibility of growing up at the young age of 16. And it's tough. Monday, when we picked the jury, I told you one is that I wanted 12 jurors to listen, give 110%, and then go back through those doors with this chart and make a decision. In a couple of minutes that you will do that. The other thing I told you was that what's going to come down to is not whether or not Cody pulled the trigger, but whether or not he had a plan, scheme, or something to aid or abet in reference to this killing. And that's where the key is. There are some givens in this case, and we know that Chelsea Shipp walked in this court without a trial, but guilty. Shoot. So we know who the shooter is, because it's proof beyond a reasonable doubt. She swore to tell an oath. You could remember the testimony that I listened from one of the detectives, and she took responsibility. So now the thing is, or what we're here today is whether or not, as with all parties, he did something to egg on Chelsea Shipp. And I think that's where the rub is. The state wants to make a big deal about she's 16 years old. He's 21. To me, they're both teenagers. Yes, legally, there's a problem. But as you well know, it happens every day. It isn't something that Cody and Caitlin went for a night and she became pregnant on a date, threatened to disclose them, threatened to do this or that, and became a problem. That wasn't the case here. What you had was Cody living by the grandparents, grandfather introducing Caitlin to him, grandfather basically giving a blessing saying, yes, date my granddaughter because she really didn't have a good life. You realize that mom wasn't around and dad possibly was in a federal penitentiary. And they had a plan. You realize whether or not through the testimony that they decided to move in together. No one said no. None of her family said no. None of his family said no. So they moved in, whether it was a week, 2 weeks, or a month. And you know that because there was testimony in reference to Facebooks, and that's how they communicated with whatever it was. And they appeared to be happy. And lo and behold, as people do, and they get together and they think they're in love, well, Caitlin thought maybe she was pregnant. Now there's 4 tests here, and they're all negative except one, and basically it kind of indicates it, but we don't know when those tests were taken and when it actually and what it was. What we do know through Facebook is that she was excited. Onesies, remember? That she was posting stuff. And I asked the detective, I said, you know, we have all these Facebooks. At any time did Cody say, I don't want to see you anymore. You ruined my life. You're on your own. You have to get rid of it. We don't want a child. No. What you heard was, I'm gonna be a dad. Guess I gotta start taking responsibility. Change of life. I was planning on a life together. Does that sound like he's trying to get rid of her? Does that sound like she's a problem? No. So it's not there. So then you heard evidence of people saying, well, what they were planning a couple of weeks at least. What was going to happen? How we were going to get rid of her? Hurt the problem. Well, we know that probably wasn't true either. Because we heard testimony that said within a couple hours before this posting happened, Chelsea found out what her age was. And went ballistic. You're in trouble. You can't be having sex with a 16-year-old. What was Cody's response? There's no problem. Caitlin and I talked about this. Whether or not it's legal or not, whether or not it's right or not, but it goes to the mindset of the two of them at the time. He says, I'm not going to get in trouble. She consented. Now we know by law they can't. She can't. There's not a problem. Yes, there is. You're going to get convicted. You're going to be a sex offender the rest of your life. No. You're talking crazy. Well, then it escalated. Now, I'm not going to try to sugarcoat this. Both Cody and Chelsea love men. Just crazy things. People. But you also get a little bit of an insight of how Chelsea was. She carried a gun. Remember? Where did she keep the gun? She kept it right here all the time. Why would you need the carrying? You heard from Miss Moon. You heard from Cody Smith. That when they found out, or Cody Smith found out that she had shot somebody, who did he think? It was Michaela, was Skip Bertrand. But she killed her. Why would you think that? Well, she dated Skip Bertrand, didn't like getting pushed out or being replaced. Because that's who she did in. She was like that. It's not there. How about Moon? Yeah, she was kind of crazy. She was kind of jealous. Does it make sense? Absolutely makes sense. But she just took it one step too far. She thought in her mind that she was going to get rid of the problem. So whatever it was in reference to whatever relationship she might think she might have had between Chelsea and Cody, that he was going to be all his. If there was a plan, ladies and gentlemen, and you have to use your reason and common sense. If you were going to kill somebody in Hampshire, if you wanted to get rid of a, would you go and plan to do it at your dad's house in which you're living? Would you then take it further and go and shoot somebody while they're sleeping in your bed? Would you do that? Or would you, as the evidence was, because supposedly the gun was thrown in the bayou or some waterway or off a bridge, would you pick a secluded place out there because it's country to get rid of it? Drive her somewhere, do it, and try to hide the body out there. Would you do that? Or would you just do it at home with dad there in the trailer at the time, while Caitlin was sleeping, because we know that she probably was sleeping, she wasn't disturbed? Or was it a random act that no one realized that was going to come? We know the body wasn't moved because the gun shell and everything else on the pillow and things like that were not disturbed. Let's take it down the next step. The last witness said, look at all the places that these people have gone. Now, that isn't what that testimony meant in reference to the officer and the borough, the GPS information. They know where the car was. They know what was inside the car. One was Chelsea's phone. There was another phone. And they're saying Cody's possible phone was there, or was there. But you don't know who the individuals were because the evidence says he never had a phone. Chelsea took it along with the debit cards. Remember, over at Arsenault's house. That's why it's in that car. That's all that he could say is this was, and that was my only question. The information came from the car, not the individuals, right? Car, vehicle. Yeah, makes sense. He doesn't have his phone. Chelsea's got to have it. Never discovered. You may be responsible for tampering with the corpse, failure to call, render aid, but that isn't what we're doing today. It's murder. Intentionally known, either individually or as a party. Mere presence, as is outlined here, is not enough to say you did it. It's tough. There's a young girl that has lost her life. They want to show, and they showed tapes, and with the interviews that you saw Cody in there, what did he say? I loved her. I didn't know what to do. Well, you had that trash can. Yeah. Could you have possibly you were going to throw the body away or get rid of it? Possibility. Well, think about that. Think about it. A person dead in your bed, not going anywhere. Something has to happen. What else? Of course. What am I going to do? has no one else to turn to, so he meets a friend at the Dollar General. Hey, help me out. What am I supposed to do? I don't know what to do. Does it make sense? Caitlin's not going anywhere, and I'm not trying to be smart or funny. She just can't stay there. What was his response of why he didn't call? I should have. I thought Caitlin was going to Chelsea was going to turn herself in. I was expecting someone to show up. Do you have anything else that says otherwise? We know that Cody wasn't over at Arsenal's house, showing Arsenal's house, because Arsenal says it was just her a couple times. Now, with the car GPS, you realize that she spent the night there until the next morning to get rid of the car back to Miss Moon. So we know where she was. The gun residue, the gunshot residue test, you heard from their expert that said it was inconclusive. It could have been a product of the environment. DNA, there is touch DNA, or there is DNA on one of the breasts of Caitlin, but they were in a relationship. I don't know where Chelsea's, DNA would come from. But there was nothing in reference to sexual assault or anything like that. That she was assaulted at the time. They want you to say the plan was because she was 16 and pregnant, had to get rid of it. But the circumstances surrounding all that are just not there. Both the amount of reasons found. There's nothing there that says, I wanted to get rid of her. And what happened was, I submit to you is, Chelsea took it upon herself for some reason to walk in while she was sleeping, put a gun to her head, fired the shot, walked out, looked at Cody and said, now it's your problem. I took care of it. And left. Because if he had a plan, he would have tried to get rid of Caitlin. If he knew what was going on and they had this big thing of this is how we had to do it, some type of preparation, some type of overt act, something that says, I was trying to get rid of the body, you would have seen. But what did he do? He just sat there. He just stayed there, never touched anything, never did anything, couldn't. I ask you, ladies and gentlemen, to take everything into consideration, totality of the circumstances. Go back and when this hatch was supposedly, or this plan supposedly was hatched, was it a couple of weeks ago or was it a couple of hours before? Take a look and remember all the Facebook things that no indication whatsoever that he was unhappy with about to have a kid and be a daddy and become responsible. It was his last weekend to party because he had to grow up. Look at everything that he did afterwards, because it would have been just as easy for him to get in the car with Chelsea and take off trying to get away and try to get away from this. It would have been just as easy for him to say, I don't want to talk to you. I'm going to lawyer up, just like Chelsea did up in Liberty Hills, Williamson County. It is a tragedy. It is just senseless, and is one that I know that Mr. Ham and I probably will remember the rest of our careers, because I've known him for many decades. I shake my head. If I forgot something, because this is the last time I get to talk to you, you may say, good. If I forgot something, if I didn't point out something, sometimes they say, well, how come I didn't do this, or I didn't do that, or how come you didn't hear this from the defense, or whatever. I mean, it's my omission, not Tony's. I did the best that I could. I tried to put things out on the table for you within the parameters of the law, so that you could see everything to make a determination. This, and I'm not trying to lead you down any fish trails, rabbit trails, whatever it is. I just want you all to listen to everything. This is just my point of view. It is not evidence. And I want you to go back there and make a decision. Case. There's nothing wrong. You're coming back saying not guilty. They have not proven this. They've got the shooter. They've got the person responsible for it. Yes, he might have tampered with something by doing nothing. Putting a plastic bag over the person that he loved. But not her. Thank y'all for the time.
State of Texas.
First and foremost, I want to thank you all for your attention. I know it's been a long week last week, and here we are. I had a good guess as to that we would get here when we were talking on Monday. A little bit delayed as far as what I was expecting, but I want to be real honest with you. Everything that's taken place in this trial is what I expected. Even down to that last argument from the defense. And I told you, I'm lucky enough that I've done this work for a long time that I can kind of guess where things are going. When you deal with someone who's not what lawyers call the primary actor, in this case, the shooter, there's always going to be the let's blame that person, right? I gave you all the example of when we were in Board Hour, and I talked with you about how we don't let the person that's driving the car, that's letting his buddy hang out the car, shooting and killing someone. They know what's going on. We hold that person responsible. And when we talked about different other analogies about that, and we use the situation of a robbery where people sit down and say, okay, you'll be my lookout, you're going to do this, you're going to do that. Don't remember those analogies. So the common argument that you can expect is that someone's going to come in and say, well, no, I didn't do any of that. That's not what was going on. That's pretty much what you just heard. The defense argument is that Chelsea did it, that you don't need to worry about finding him not guilty because somebody's being held responsible for it. But that is not what the rest of the evidence shows, right? That would ignore every other thing that we heard last week. They would love for you to say what he did wasn't murder. They would love for you to make a finding that he had no responsibility or I didn't prove it. let's get back to what the facts are. In this charge, the defendant is on notice and has been on notice that I was going to hold him responsible for the death of Caitlin Stone. The only thing that is at issue is whether or not he acted as a party. That's it. Because I basically said Chelsea Ship did it, right? So they're admitting that on or about March 26th, right here in Jefferson County, that Caitlin Stone was intentionally and knowingly killed by a firearm.
Hold on for just a second.
Sorry, Judge.
Your presentation is made in a conjunctive, intentionally and knowingly. The jury instructions are different, ladies and gentlemen. They are what carries the day. The law provides that a person can be held accountable for murder if it's proven they intentionally or knowingly, disjunctive or knowingly, caused the death of another person. So be very careful about that. But it's proper here in the jury instructions for you to refer to. But the way that is presented, which infers that it's the burden of the state to prove intentionally and knowingly, which are two different types of culpable mental states. That is not what the law states. It is, the law provides for the disjunctive. Go ahead. Thank you.
Forgive me for not putting the word or. These folks killed him. There was no doubt. It's not like some act of passion. They did it in cold blood. So what you're going to be called upon to decide is just like that slide I was talking to you all Monday of last week, is what was his role? What did Cody Arnold do? Because that's what it all boils down to. Chelsea Ship pulled the trigger and killed her. But why? Why? We learned the why from some of the witnesses that I'm going to clarify that for you. But even if you don't accept what some of those witnesses said and did, remember, and I'm going to go over this, I've got slides about it. Remember the words out of his own mouth about what he did. All I've got to show is that he acted with intent to promote or assist the commission of this offense. He can do that in many ways. In this, right off the bat, the concept of getting rid of the body, which he admits to. The deeper issue that's really disturbing about this young man is whether or not he actually encouraged Chelsea Ship to do it. Whether or not he got into her head to take care of his problem. That would clearly be soliciting and encouraging, directing, aiding, or attempting to aid in this offense. So how do you decide? Both Mr. Burbank and I have told you, you need to use your common sense. I've had this case from the onset, just like Mr. Burbank. And my greatest fear is that because I've had it so long, is that maybe I won't break down my understanding of it for as long as I've had it. You genuinely think that if I thought there was some issue about Cody Arnold's role in this, that I thought for a moment he didn't know what was going on, that I'd actually stand here? Let's get real, folks. That's part of common sense. He knew what was going to happen. And there's going to be a lot of little subtleties that makes it really clear. First witness you heard from was Danny Powell. And this is unbeknownst, I prepped this before Mr. Burbank argued. He said, he reminded y'all that what Mr. Arnold said was he was going to tell the cops. Remember, there's that whole interview. Well, that body was there. The whole reason why it was there is I was waiting. Chelsea was supposed to turn herself in. I was waiting. I was waiting for them to show up. I'm going to tell them. Okay. And that's a false answer because the man is lying. When they're right there on his doorstep, what does he say? Where's Caitlin? He didn't say, hey guys, come on in. She's right back here. I can't believe this is what happened. That's not what he said. He said, she isn't here. She's in Biter or she's in Orange. I haven't seen her since Friday. Lie, lie, lie. People lie when they know they're in trouble. People lie when they don't want to be held responsible. People lie when they've done something wrong. You know, the devil is in the details on this. So Cody is lying from the very minute he opens his mouth. We're brought in that second witness. His character. Y'all remember that. This good old country boy. Kind of upset with me about why he was here. He got arrested, ended up here. But he made it really clear that the words out of Cody Arnold's mouth is he needed help getting rid of Caitlin. And you remember how mad that made Eileen once he figured it out? He said he hit him. When he realized what he was really asking, right? This is factual evidence of his part in the plan. Factual evidence of his assistance to get rid of the body, not tampering with the body. He was finishing the act of murder. Remember the whole concept of accomplices before and after the fact? Everybody knows. I mean, it's a common sense saying if you kill somebody, you might want to do something about the body. Then we get into the hearsay about what Chelsea Shipp is telling folks. You heard from Brandy Moon about how they met on that Saturday at noon and they swapped cars. I still haven't figured out what that whole car swap thing is about. But they get the car and she goes, and we're going to get to the Burley report that kind of affirms a lot of this stuff for you all. But Brandy wants her car back. So she sees Chelsea the Sunday after the murder, right? Within that 24-hour period, and she says there's something wrong with her. She's acting oddly. And she said, well, what's going on? Cody asked me to take care of a problem. Those are the words out of Chelsea Shipp's mouth. Not, hey, I decided to do this and whatever. It's Cody asked her. Acting up, solicits, encourages. Now he has to do what he has to do. I mean, he's got to get rid of the body. We've already gone over the factual evidence that supports that he was doing his part till the cops showed up. Then we hear from Cody Smith. And again, we hear from another witness who the whole reason, I'm going to tell y'all ahead of time, the whole reason why the Burley report is coming in, and it's one of the last pieces of evidence that I have for you, is because that report supports everything these folks tell you. He gave you a time frame talking about 15 minutes in his driveway. Lo and behold, this shows that the car was sitting there at his house for 15 minutes. Can you imagine if somebody questioned something that you said and you could go and pull and say, well, look, here's proof they were right there, just like I said. So what else does he tell us? He states they had a plan. Chelsea was freaking out over the fact that she was actually pregnant. And that Cody's going to be in trouble. He's going to be a sex offender for the rest of his life. Chelsea's telling that to Cody. Can you imagine what she must have said to him when he said she was freaking out over finding out she was 16 years old? Mr. Burbank tries to tell you that, hey, you know, everything they did was stuff that happens. First off, I'm offended by that argument. It's a crime for a 21-year-old to have sex with a 16-year-old. It's the offense of sexual assault. It results in somebody having to register as a sex offender for the rest of their life. See how those facts fit in? All telling us that Cody Smith is telling you the truth. Nathan Staggs testified. And we were still dealing with this whole thing about was she pregnant or not? You know, we got caught up on that little side trip. So I brought the Facebook messages to show you they were talking about it. She may or may not have been pregnant. We know after the autopsy that she wasn't. But if one of his statements was that baby in love equals marriage till death. So let's pause it for a second. Maybe Burbank's right. Maybe Cody really did love David. Maybe. And maybe he did think it was okay that, hey, she's 16 years old and I met her through her grandpa and we've been doing this all this time. Hey, we're going to have a kid. Maybe he did think all those things. Maybe he did think baby and love and all that, and marriage till death. What changed? What changed? Caitlin, Chelsea Ship convinced him that he was going to be a sex offender. Whenever that baby comes out, there's the physical evidence that you committed the crime. You're going to be a registered sex offender for the rest of your life. He didn't think that. If you buy into the statements, right, and the arguments. I don't know. I find it ironic that what we're standing here talking about is she's dead. And his words were till death. So let's not get caught up into when a lawyer said that the child was 16 or 17. She was 16. She was 16. I want to repeat that. She was 16. She was not an adult. She cannot consent to all these things. Cody admitted in that first interview to be in all the places that everybody says. And then he had that, I'm going to go ahead and be kind and say it was a Freudian slip. All right, y'all familiar with that phrase, Freudian slip? He said in that first interview, and I paused it, played it for you, I'll let you listen to it. I repeated it a couple of times. He said what he did. And then he changed it. He realized the mistake he made. Right? Thinking he can move past that. That second interview, and I put the times up here in case you guys really want to go back and listen to it. About the 11:30 mark, the 11:34 mark. This is when he's Detective Powell, God love him, is right in his face, being confrontational. He's the bad cop. And Detective Williamson is trying to say, hey, hang on, and talk to him. He's being the good cop. And the end result we get in that 4 to 5 minutes is admissions. They're admissions about this crime and what makes your decision so easy. He admits right then that he talked to Ivy about getting rid of Caitlin. Then he says, oh, what's this for? I showed him the picture. Show him a picture of this. What's it for? You can open it up. Y'all know this is empty. And it's right there by her body in his room. What's this for? his words. I was gonna get rid of shit. And I stress that word because on the tail end of that, when he's asked what that is, he has the audacity to say clothes, pillows, comfort. I'm offended. I am offended that we've been sitting here this whole week listening to how he supposedly loves this woman, that there was nothing that he would do, that it was just this other person, and he lumps her into a category of shit and says he's going to put her in here. And that's what this is for. That's why this is brought to you so you can see it. Let it sink in. Facts are hard to find. This body is in his room, in his bed, and he calls her shit. In my mind, this is a sex offender and a method. Those are his admissions. He's a sex offender. He just hasn't gotten the label because he hasn't gone through trial and all. He would be required to register for the rest of his life as a sex offender. He is a dopehead. That's what meth is. And people that are on dope like meth, they don't do things that make sense. They do this stuff. Caitlin Stone's not here to talk to us. We've heard, I just was going over with Cody, what we learned from Cody. Through other witnesses, I've talked with you about what Chelsea Shipley today. I want to spend a little bit of time talking about Caitlin Stone. As I prepared for this trial throughout, I early on got this picture of Caitlin from family to help keep me focused in on holding Chelsea Ship responsible. And you've heard she's pled, that's done. But my journey is not done until you're done. It's about holding him responsible. One of the things I learned last week is that her favorite color is green. I wore the green bow tie today for her. Having raised two daughters, it's hard to look at it and deal with this evidence. I think that if Caitlin was here, she would tell you, hey, I didn't do anything wrong. I thought I met a guy I really liked. I can gather from the Facebook messages that you've heard that she was excited. There's no doubt when you look at all those baby photos, that little girl was excited. It's really sad when we think about her excitement and pregnancy or not, is probably the whole reason why we're here. I don't have to prove much, but the evidence seems pretty clear to me about that. So the judge gives you a charge. This is contained well within. And we all know that Cody Arnold did not act individually. We know here that he is a party to the offense. Seems like every time I argue one of these cases, I make sure to point this part of the instructions out to juries. You know, I'm talking to you about, it doesn't matter when I come down here in trials. Lawyers always say all kinds of crazy things. Okay. In the charges, questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. I need to remember at least one instruction that the judge gave you during the trial about that. Right? You'll remember my objection where I would say sidebar, and the judge would pull that back. You gotta ask questions, and the evidence comes from answers. Okay? If I've stated something that goes against what this law is, this judge tells you, you get to disregard that. The same thing is true for Mr. Burbank. Right before you get down to the last thing, you all get to determine what justice is. It is your responsibility to make sure that justice is done in this case according to the law and the evidence. Okay? The law does not say that if a 21-year-old and a 16-year-old get together because the 16-year-old wants to, then it's not against the law. That's what the law says. Right? And I'm using that as an example. The law says that if somebody was a party to the offense, you hold them responsible. This girl was murdered. The evidence is overwhelming as to her murder. The only just and right thing is holding him responsible for his actions. I was going to put my notes up. Sorry. I was remembering how when Detective Powell was testifying, and they talked about leaving that body there for 30 hours. Remember? And you remember how emotional he got? That doesn't happen if what you were truly going to do was tell the cops. You would have told them that right from the beginning. This is State's Exhibit 54. This is so telling. We start at 12 o'clock because that's when the officers understood that they actually get Chelsea and Cody took possession of the car. You know that from witnesses, right? But and again, I told y'all, kind of stole my own thunder. Part of why I like this piece of evidence so much is it affirms everything you've heard from these witnesses to just almost like somebody was there saying, yeah, what this witness is telling you is right. I got to respond to Burbank's statement. He never had a phone on him. He had one connected to the system. Whose phone do you think is Cody's MF iPhone? You know. That's that common sense thing, right? Okay. The witnesses tell you two people show up, they get in the car. They tell you it's Cody Arnold and Chelsea Shipp. That's how we know it's his phone. And they're at the Crystal Beach. What do? they go and they travel and they end up at his house, Paul's Corner, where they're there from roughly 1:52 to 3:36. You remember where they went from there? They go, they run by a McDonald's. The witnesses told you that they showed up, that they were eating McDonald's. And this is at 4:30, when the evidence and the suggestion is that this time frame between 1:52 and 3:36 is when Caitlin Stone was killed. That's key. Remember, you heard through the testimony, 2:30, 3 o'clock. This is that time frame, right? So after they go and they pick up McDonald's. Let's go pick up some McDonald's after we shoot somebody in the head, right? And what do? They're hanging out at the Redneck Riviera, and I said, how are they acting? They're acting like a couple. You remember that testimony with Brandy Moon? Here they are eating their McDonald's after that poor girl got killed, sitting at the Redneck Riviera spot that's here at Highway 124 from 4:30 on to when they go back to his house. What does any of that tell you that he didn't know what was going on? He knew exactly what was going on. Y'all, if he saw it happen and quote unquote freaked out, he wouldn't be sitting there eating, number one, and two, playing footsies with some other girl. And then the cover up goes on. Trying to figure out what to do now, right? We got a dead body. She ends up going over to Stoney's house, affirming again him, the gun, tracking it back. It was used. They tried to get rid of it. We managed to track it down and get it. Going back and forth there, showing up at Cody Smith's house. Having that 15-minute conversation is affirmed right here, where she's telling Cody Cody Smith, that her and Cody Arnold had a plan to get rid of her. Goes back, exchanges the car, and then it's gone. And I'm pretty sure that Chelsea Ship's attitude was, hey, I did what I was supposed to do. That body's on you. Because that's what the agreement was. The physical evidence, interesting enough, really affirms some other things as well. The DNA tells you his DNA is on her right hand here. His DNA is on her breasts. Well, why bring that? It's to show that he was involved, he was there. I don't know when he handled her. I mean, I can get into all kinds of creepy thoughts about what happened when that poor girl was laying there after she was dead. I don't want to go there. What I know is that his DNA is on her. Just like I know there's GSR particles. This concept that he didn't know what was happening, oh, none of that makes any sense in the big picture of events. So what they'd like for you to do is just, hey, Chelsea's already fled, let's let this guy go. That's not justice. Casey's in his bed, where that girl was covered up. She was shot in the head like that. The only thing that girl did wrong is have a relationship with that man. That BS about I was getting ready to tell the cops, he had his chance. He didn't do that. He just left her there for 30 hours. To which the law enforcement officer with years and years of experience who had to walk in and see that initially is still emotional about it. Let me put that trash can right there. Now, I'm gonna leave that picture there for a moment. Because I want to point something out to you. The whole pregnancy test thing. The receipt in here shows that they bought it. I don't know, one of those dollar stores. I don't remember the name of it, right? Let's say Family Dollar. I don't remember. It was March 24th. I know that. And I know this happened on March 26th. And I know that the pregnancy test was pulled out of this trash can right here. 2 of them. And that 2 more were right here. Right next to her. And I guess they were just he was just hoping that this trash can was big enough to fit her. That 5'1", 95-pound little girl. I could have folded her up in that. I got this in evidence because I wanted you to see it in closing. This is a to-do list that he had hanging on his wall. This tells us a lot more about Cody Arnold. Label, when I get out to-do lists. Get a job. Slow down on smoking. Maybe, I think he meant to spell the word quit. It says quite. Get tatted up. No more cigarettes. Again, there's a lot of language here I'm not going to repeat. Right off the bat, there's some language in that next line about people he wants to stay away from. Find a girl worth keeping and comfort. Don't cheat or fuck it up. Anybody else see the irony of that hanging in the wall with this poor child that's been shot dead? Words, actions. That's what really tells us a lot about people. I told you, I made the argument that you can make the right decision easy in this case based upon the details. The argument presented to you is, hey, I didn't know anything was going on. I'm an innocent guy. She did this. I was going to tell the cops. He had that chance, and that is why I keep saying that's a lie. Everything this man said was a lie. I don't think he thought he found the right girl. I think, and the inference is that Chelsea convinced him how much trouble he was in. And then they talked about how to get rid of her. And I think they smoked enough meth that they actually did this crime. Because we know it happened, right? We know they ran up and down that road and that they were smoking the meth. We know they sat out in that car whenever they got back. And we know, according to the statements that were put into evidence, that they go in there, according to him, that he went into the restroom to use the bathroom, and he came out, she was over her and had done it. It's all that crazy talk that he mentions to the officers beforehand, that he doesn't give the details on. That's when they were talking about the plan. That's when the truth really is in there. Chelsea pulled the trigger, but it was at his encouragement. He acted on his part of the plan by allowing this to happen in his room, by getting that trash can so that he could get rid of the body. He talked with others about it, and others affirmed that it was their plan all along. There is one and only one just and right decision to hold people accountable for what happened to this girl who did nothing wrong, didn't do anything wrong. Justice for Caitlin is a guilty verdict to this man for being involved in her murder. I await your verdict.
Ladies and gentlemen of the jury, at this time I am tendering the jury charge to the bailiff. I'm going to ask the 12 of you in the jury box to please step down, follow the bailiff into the deliberation room. We will await on a verdict. Under the law, only 12 members of a jury are allowed in a deliberation room. We're going to ask the alternates, if you'll be so kind, please hold vigil and wait. We'll keep you updated. We have had to replace jurors during deliberations. That's why we have alternates, because there has to be 12 decision makers unanimously. And if one is unable to continue, we've got our alternates. So we're going to ask you to stand by with us throughout the duration until the end. Thank you very much, ladies. And you are. And for the record, once again, ladies and gentlemen of the jury, I have received and accepted your verdict finding the defendant guilty of the offense of murder as indicted in this cause number 2240127. This brings us to a close of phase one of a trial, the guilt or innocence phase. We will now proceed with the second phase of the trial, the punishment phase. And once again, I will repeat, please, you are still under the instructions previously given to you, and I trust you shall follow those. State of Texas may call your first witness.
I tendered to Defense Counsel States Exhibit 55. They are certified copies of documents of clause number 1728364 in the Criminal District Court of Jefferson County regarding Cody Lee Arnold. It consists of 3 different documents: a deferred adjudication order, a motion to revoke, and judgment and sentence.
State's Exhibit 55 is tendered into evidence. Any objection?
No objection, Your Honor.
It is admitted and made a part of the record, and the state may summarize what State's Exhibit 55 consists of for the benefit of the jury.
So in essence, anytime somebody is placed on probation, they get what's called a deferred adjudication order. That is a portion of the state's exhibit 55.
Can we,
I will, Judge.
thank you.
I want to point out that the date is when this was March 5th of 2018. You'll see the pertinent information here that it's regarding Cody Lee Arnold. Here out of the criminal district court of Jefferson County. You'll see on this that the offense was criminal mischief, that he received probation for a period of 5 years. And when you review this document, if you choose to, you'll see that there's standard conditions regarding probation. And this actually takes it's a total of 4 different pages as to this document. From there, the second document in that is what's called a motion to revoke unadjudicated probation. Again, it identifies the name Cody Lee Arnold and a cause number here in the criminal district court. You'll see that I was the one that was prosecuting him, and the information about him being placed on probation for a period of 5 years, and that the accusations are that he broke some laws against the state of Texas. You'll see in a moment, one of the other documents shows that he pled true to count 1, which is this offense here of possession of controlled substance on February 8th of 2022 in Chambers County. You'll know it's Mr. Arnold because you see right underneath that the offense that he is accused of here that you have found him guilty of in count 2. Now, he did not plead to that in this one, but this is the motion that went notifying him. He entered the plea as to that particular motion, which said that he violated his probation. That's in cause number, same cause number we're dealing with. It follows from that deferred adjudication in cause number 17-28364. And then the actual document that is the judgment that I attached the number to, it states 55. That's where he was found guilty. You'll actually see the parties are involved here. Mr. Burbank was his defense counsel. I was the attorney for the state. That's the offense that he was on probation for. Those things match up. You'll see where he pled a count 2 to count 1. And you remember that's from the motion to revoke separate charge for possession of controlled substance in Chambers County. And then the sentence he receives here was 2 years state jail, which started back on February 8th of 2023. This document itself consists of 6 total pages. But that's the pertinent information that the state would like to publish.
Any objections? Any further objections from any statements made on the admission for that?
No, just that I was the attorney of record, and we pled in front of the court with an plea agreement between the state and defendant for the time,
Right.
based on the totality of everything at the time that was going on.
All right, just a couple of things, ladies and gentlemen, and the request states Exhibit 55 be admitted for purposes of the review for the punishment phase of this trial by the jury is granted. Just a couple of technical matters. When a person is placed on probation, there are two types of probation in the state of Texas. There's what's called regular probation, which is the historical form of probation, where someone is found guilty, sentenced, and then that sentence is suspended and they are placed on probation for a period of time. And if the probation is revoked, they can be sentenced from the minimum up to whatever the sentence was that they were placed on probation for. Then there's the other probation that came along 25 years ago or so. And it's called deferred or unadjudicated probation. And that's where that's something that a jury cannot give. It's only allowed if a defendant pleads guilty on their own unilaterally. And then they are placed on a period of probation and they are not found guilty so long as they follow the terms and conditions of probation. If they violate the probation, then they can be then found guilty by the court and sentenced to the full range of punishment for the offense. And that's what's called deferred or unadjudicated probation. Any finding of guilt is deferred so long as they follow the terms. If they don't, then they can be revoked, then found guilty and sentenced. And in this was a state jail felony. So he was looking at no less than 180 days up to 2 years in the state jail. And that was the lowest punished felony offense, state jail, then third degree, then second degree, then first degree capital murder. Those are the levels of felonies in the state of Texas. All right, State's Exhibit 55 is admitted and the state may proceed.
We recall Gerardo Valencia.
We're about to give so help you the truth, the whole truth, and nothing but the truth. So help you God. Please have a seat there. Thank you. And we're going to make sure you get the microphone toward your voice.
What's up, Valencia? Oh, you're gonna be all right. So keep your voice up just like that and in good shape. Go ahead and state your name for the record, please.
My name is Gerardo Valencia Jr.
Mr. Valencia, what do you do for a living?
I'm a correctional officer for Jefferson County.
That's the uniform, right?
Yes, sir.
I brought you in from the job today. What shift do you normally work, sir?
I work the 3 to 11 shift, evening shift.
And how long have you been doing that job?
I want to say around 3 or 4 months.
What kind of training does it take to be a jailer, a correctional officer?
Well, the training is they make us do 2 shifts on morning, 2 shifts on 2 weeks on morning, 2 weeks on evening, 2 weeks on nights. They let you get a feel for it for the first week. And the second week, they kind of ghost you, leave you just to see if you can handle it, cut you loose.
But are you off your probationary period?
Yes, sir.
Okay. When did you start with them?
I want to say around November of last year.
Okay.
November 2020.
In your dealings and in your capacity out there, have you come in contact with an inmate by the name of Cody Lee Arnold?
Yes, sir.
You see him here in the courtroom today?
Yes, sir.
Can you point to him and identify something he's wearing, please?
He's wearing like a white beige shirt.
Is he wearing a jacket? Just the shirt, right? No tie?
But
You want to make the record reflect he's identified the defendant Cody Lee Arnold?
Yes, it will.
And were you working in that capacity back on March 8th of 2026?
I was working with Mary Dorn. Mary Dorn is basically, well, that's the maximum security of it.
Right, so is that commonly called M dorm?
Yes, sir.
And does the M stand for Mary?
Yes, sir.
Does it also stand for maximum?
No, sir.
Okay, just Mary.
Yes, sir.
Okay, who is normally housed out at the Mary dorm?
Mary Dorn is normally for the inmates that are kind of level headed, but they still cause problems, and they're not fit to be on a regular dorm than the other ones.
It's a little bit more secure?
Yes, sir.
Are there less prisoners in number
From,
or more guards?
well, it's two guards that work married dorm, but
Okay,
they're all in single cells.
okay,
Then in the dorm, they're all wandering around on the dorm.
all right. So that's the difference, is you got a single cell setup versus a general dormitory type setup?
Yes, sir.
All right, so you were working in that capacity back on March 8th, 2026.
Same.
Did you have an issue with, as you named it, inmate Arnold?
Yes, sir.
That's the same individual that you talked about already, yes, that you've identified? So what was the issue?
Issue. He he threw something to another inmate because Arnold was in cell 29 and inmate Shallow is in cell 34. That's like a straight runaway. So I'm sitting right here, from my right here to where that door is over there. I see Arnold throw a box, and when the box hit the ground, it lit up. So I go over there to question Shallow because Shallow hurried up and picked it up. And I said, "Oh, he said no, it was in the box." I'm like, okay. The only reason why I walked away so fast because it was already shift change and no supervisors was back there. And as I'm walking away, a bag fly over my head and I pick it up. And that's when inmate Arnold started getting aggressive. I'm like, bro, what's going on? Then he started reaching at me. So obviously that's showing me that something was hidden inside the bag. So I pour it out. So that's when I walk away. And he throws the full thing of deodorant and he hits me. So I go back and question him. I'm like, what's going on with you? Then he fixes his mouth to spit at me. That's when I gave him a push to the chest to get him away from the cells.
All right, so you're giving the jury a lot of information. In dealing with inmates, do you frequently have issues where someone may be aggressive with you?
I mean, yeah, that comes with maximum security, but they'll be more verbally aggressive than.
Sometimes they'll run their mouth and
Yes.
are there times when they'll do something that is more than that, more than just talk, that they'll try to physically do something? You mentioned that he tried to spit on you.
Yes.
What's the concern from a correctional officer's standpoint about somebody's bodily fluid coming in contact with them?
Well, bodily fluids, you never know what anything I have, and due to me being at the cell, it could have ended up in my face and spitting inside your eye. If the inmate has something, then you have it too. So
Possibility of getting a contagious disease?
yes,
Is that why you pushed him in that regard?
yes.
Had you had dealings with Mr. Arnold before this?
I mean, we had one verbal incident that was before this happened. That was about it.
So if you had to describe him, was he the kind of guy that was going to give you problems, or was he the kind of guy that you didn't really have to worry about?
I want to give it a 50-50. Sometimes he gets irritated, sometimes he don't. Only when you snooping around, that's when he gets irritated. Like if you go in somebody's cell, he'll get irritated. You try to stop what they got going on, he'll get irritated, but that's the only time.
I didn't pick up on this when we visited originally. It picks up, it sounds like this is happening right at the end of your shift.
Yes, sir.
And what time was it?
It happened at, can I refer back to my
Sure.
thing? It happened at 10:30. 10:30, that's when shift usually comes in route, and that's when all the supervisors go up to the front. That's when the new shift is coming to the back.
Is there a greater chance that inmates may act out during that shift change?
I would say,
Is that what you kind of put this into category?
yes, sir.
All right, so officer, are there times when things like this happen and you don't write a report?
Yes, sir. Sound like this do happen, but it depends on how deep the situation is. The only reason I did it because I was just covering what I did because I did put my hands on him, and I was just doing that to make sure I was safe.
All right, so in this regard, you wrote this report for that reason.
Yes, sir.
All right, so let me make sure I understood it, because if I've got some questions, I don't want them to have questions. Sounds like you initially saw, you said a box land near inmate Shiloh's cell,
Yes, sir.
and you said it lit up?
It lit like a little fire, like sparks, fire lit up inside the top.
All right, so when you say that, you are talking about something caught fire?
Yes, sir.
Did it extinguish itself?
I couldn't really tell. I just seen it lit up in a box, and then it was. That's when we hurried up and picked it up.
What did that make you think it was?
Obviously, they were trying to smoke. That's
Smoke something.
an ongoing issue and everything.
All right, so let's make sure that jury understands that. It's an ongoing issue in Mary Dorm that folks are smoking some substance?
Yes, sir.
Is that in violation of the jail rules?
Yes, sir.
Is that why you were investigating a little further?
Yes, sir.
Part of your job, right?
Yes, sir.
And you said something went over your head,
Yes, sir.
and when you went to investigate it, inmate Arnold didn't like that. Is that a fair summation, sir? That's witness.
Good afternoon.
Thank you.
Could be better. You still in M dorm, deputy? You still in M dorm? M,
I go. You got married dorm, then you got nowhere dorm. So I work both.
okay, are you still working there?
Yes, sir.
And do you still come in contact with Cody?
Yes, sir. But there's no issue. There's no issue there.
You're in a max or a high security location at the jail, correct?
Yes, sir.
And approximately how many people are in there, along the M dorm?
You have,
Roughly, how many inmates?
you have 54 in total. That's because you have 48 on a run, and in ISOs, you
Okay.
have 6 of them.
Okay, and that's just one dorm.
Yes, sir.
And how often do they get out, outside?
I don't know how that works. Morning shift is the one that takes them outside. Our shift are the ones that take them to the day room.
Okay, so they get maybe an hour, is it a
Yeah.
day or is it a week?
They get an hour every day.
Okay.
It alternates.
And the cell, you said there were single cells,
Yes, sir.
and how big are the cells?
This is normal size cell. I hate you.
10 foot by 5 foot, 6 foot?
I would say I never measured the cells.
Huh?
I never measured the cells. I saw one.
Not big.
Not big. This-
Are they locked in the cell or are the cells open?
The cells are locked, but we have to radio up to the picket to open the door.
So somebody would stay in these cells 23 out of the 24 hours a day, unless they go to the day room or maybe outside.
Yes, sir.
And the cell doors are locked.
Yes, sir.
And these people here, have committed offenses, right?
Yes, sir.
For instance, Cody now has been convicted, but he was there under a murder charge, correct?
Yes, sir.
So they're not the best of people, that charge wise, correct? And they're all confined in one dorm.
Yes, sir.
It would be kind of normal that people would have problems, correct?
Honestly, I can't answer that. I don't know.
Well, and I guess you can't because you wouldn't be a jailer if you were having problems like the people in M or N dorm or wherever it is, right?
Mm. It really depends on who the person is,
Yeah.
because every Sunday at work I have no issues with it. It all depends on the inmates. If you have issues that they.
And in this, there was something thrown and there was some type of whatever the bag was thrown. And you went up to him and he looks like he was attempted to spit at you and you pushed him back.
Mhm.
Was he in a cell?
Yes, sir.
Did you open up the cell door?
No, sir.
So through the cell, you pushed him
They
back.
have a food slab this big.
Yeah, but did you push him back through the cell?
Yes, sir.
Well, you put your hand through and push him back.
Yes, sir.
So you actually walked up to the cell.
Yes, sir.
They're like a caged animal. They're in a cage. Well, if it's a small cell and the bars are closed and it's 23 hours a day.
Yeah, I don't know if we're gonna feel bad, but that's fast. That's not unacceptable. That's on us.
And you know, he's been there for quite a period of time, right? Okay. Did you work this week?
Yes, sir.
And did you talk to him this week?
Still give him go sit there. I mean, he gave me no issues.
Yeah. So, I mean, you're still working with them
Yes, sir.
and, or supervising. Okay. Thank you, Tim. Pass please.
No further questions of this witness, Joe,
Is the man excused?
please.
You are excused, sir. Thank you. Next, please.
Lonnie LaBeouf. Would you move that chair a little bit? That would make things about easier. Let's change it back there. I'm gonna move this forward. You can just up here testify before.
No, sir.
All right, this will be a good first time for you. Please state your name for the record, please.
Lonnie LeBeau,
And sir, what do you do for a living?
I'm a correctional officer for the Jefferson County Correctional Facility,
How long have you worked for them?
10 months.
I think I just pulled you from some training, didn't I?
Yes,
What were you training on?
defensive attack.
And you were doing that actually next door, weren't you? Did you learn some good stuff? Ironically, I think that might apply to what we're going to talk to you about here today. You remember?
Yes,
Okay. Were you working for the sheriff's office in that capacity as a correctional officer back on February 3rd of 2026?
yes, sir, I was.
And were you working a particular shift?
Yes, sir, I worked in 3 to 11.
Is that given a particular name? Just 3 to 11?
Playing shift.
And as a correctional officer working a shift like that, what are your normal duties, sir?
We do rec, morning, afternoon rec, but where I'm specifically stationed at mostly is maximum security. Where we do day room times, things like that, do our security rounds, taking visitation, things like that.
All right, so what dorm were you assigned to back in February of 2026?
Dorm called North Dorm,
Nora, also called in dorm?
yes.
And why is it given that classification?
It's a maximum security dorm for, medium assaulted inmates, escape risk inmates, behavioral issues, mental health issues.
Is that situated with isolated cells? In other words, they don't have roommates?
No.
Single cells, correct?
Yes.
All right, we're going to introduce a term for the jury. Term is dashed. What does that mean?
So an inmate will throw, feces, urine, sometimes water if you're lucky, at you while you're making your security rounds.
How does that happen that they're able to throw something like that on you?
I mean, how does it happen?
Yeah, how does it happen?
Well, they make these, they can use, cups, bowls, which, they have those, they'll use bottles and they'll stick a pin through it and take the cap off and take the insides out of it. And when they fill it up, they squeeze it and it shoots out
And that can be urine,
urine or feces, water, stuff like that.
sometime a mixture of all. How many times have you experienced that in your 10 months? Or
With feces, just once, urine twice, the rest has been toilet water, just things like that.
just part of the bad behavior that happens out there? Right, so you've had one time where an inmate threw feces on you. Who was that inmate?
Cody Arnold,
Do you see him here in the courtroom today?
yes,
Can you point to him and identify something that he's wearing?
white shirt,
Is he the one that's not in the suit?
he's not missing.
You want to make the record reflect he's identified the defendant Cody Lee Arnold.
Yes, it will.
Was that in fact on February 2nd, 2026? When this happened, when he threw that on you, was that February 2nd
Yes,
of this year?
yes,
So till they're in the indoor?
yes, sir.
Well, how did it come out that Mr. Arnold decided it would be a really good idea to throw feces on you?
He was making statements that he wanted to be moved, to a different dorm. Uh, and I advised him that it's not the way to go about it. You know, we have supervisors that will make rounds through the dorm. And, they do have a chance to speak with them. And sometimes the supervisors do get busy, but for the most part, they do their best to get back there and make the rounds.
Was he trying to make those demands of you?
To speak to a supervisor?
No, as far as getting moved.
Oh, he was stating that he wanted to be moved.
Okay.
And he wanted to speak to a supervisor, and of course, it happened after the incident.
He got to speak to one after that. Is it possible he did this so he could speak to a supervisor? Is that something that happens out there at the jail as well?
Yes.
Now, sir, are you familiar with the fact that this is actually a criminal offense for someone to throw bodily fluids on a correctional officer? And it's called harassment of the public servant, correct? I think you had just told Mr. Arnold that the day room time had concluded. Is that true?
Yes.
Did he comply with whatever needed to happen after that?
No, sir. He refused to submit the hand restraints and, was demanding to speak to a supervisor, in which told him you'd have to wait until one comes and makes his security rounds, because they get busy out there. They, you know, they can't just come. They have 800 and some odd inmates at any given time there. There's a lot of people that need to speak to somebody, so it's not just gonna happen at the drop of a hat.
So if an inmate is getting day room time like Mr. Arnold was there, do you normally put them in hand restraints and bring them there and remove them for the day room time?
Yeah. So,
And is it the norm when it's done that they get the hand restraints and they're transported back?
quarterback is-
And do I understand correctly, he just refused to comply with that? So how did you handle that, sir?
Told him, you know, I tried to tell him to go about it the right way, to wait until the supervisor walks through. When he was getting visibly irritated, but
So when he's visibly irritated, are things potentially getting problematic for you?
things would escalate.
Yes, sir. That's the proper word. Things start escalating, right? So how'd you manage to get him back to his cell, or did you?
So, once I, advised him that his day room time was up, he refused to submit the hand restraints. I had walked over to another cell, it was number 14 cell, and tried to get him to come out for day room time and asked him if he wanted to. And at about that time, while my back was turned to him, I felt something hit my back, and it went all the way up back of my head. And I could immediately smell feces. And at that point, supervisor came over immediately and spoke with Arnold, and we placed him back in the cell.
And did you see what probably sent that flying? Did you figure out what hit you besides the substance?
Did I figure out what hit me?
Yeah, you said it was feces.
Yes.
Was there an actual object that was thrown with it, or?
Just the feces out of the bottle.
That was what I was getting to. Did you determine it came from a bottle?
Yeah.
How did you determine that, sir?
I could see it. Visibly see it.
In his hands or where? And was it like that, what you described to the jury about how it can be collected and then squeezed? You've actually gone through the process to try to file those as a criminal case, right, sir? All right, so was he ultimately moved out of indoor after that incident?
After some time, he was, but it was quite some time later, I would say. He continued, good behavior after the fact.
That was my question.
Was able to be moved after.
Do you ever give you any more problems besides this day? And are you still in dorm?
I work, Nora dorm and Mary dorm with you.
So you've seen him in both dorms? And no additional problems from him? That's witness.
We have to do the deputy. So how many people are in dorm? Or,
Go ahead, I'm sorry.
yeah, how many people are in there? How many inmates?
48.
Huh?
48.
48. And we heard that there was 60 something over in M Mary dorm.
60 something inmates?
Yeah.
That's impossible.
Okay, how many people are over in M dorm?
48.
So they're both 48s? Huh? And they all single cell?
Yes, sir.
And when they go to the day room, do they all get together? Or are they single?
They're all by themselves. They get an hour a day.
Every day?
So,
Well, if there's 48 and it's an hour and they're sitting by themselves, there's not enough hours in the day.
okay, so we have 4 day rooms set up.
Okay.
So 4 come out, but there's one in this one, an A day room.
Alright.
It's separated by Bravo day room, we call it B day room, and then on the other side, where the picket is, C day room and D day room. And we also have people that do refuse to come out during the day, so they don't want to come out. That's this process long,
How long have you been working at the jail?
10 months.
And out of those 10 months, how many times has something been thrown at you, either water, urine, feces, or whatever?
Like I said, once feces, twice urine, and the rest of the time it's been toilet water or any kind of liquids that they get.
How many times was that?
I would say upwards of about 25.
25 times over 10 months. Have you ever been written up?
Not to my knowledge.
Yeah, nothing, you didn't get into any fights with any of the inmates or anything?
I mean, I have been in a uses of force, yes, sir.
Okay, so use of force,
Yes.
okay. On February 2nd of 2026, you had words with Cody, correct?
About his day room time.
Yeah. And it kind of got out of hand going back and forth, right? He didn't want to leave or what?
Nothing. Didn't want me.
Didn't want to leave. And so back and forth, some profanity, swearing.
On my end,
Yeah,
not to my knowledge, no, sir.
okay. So how did you actually get him out of the day room?
Well, after he had asked me what we call it, the supervisor came up and spoke with him and we were able to talk him out of the day room. We submitted the hand restraints.
Okay.
Once we did that, we got him in the cell.
So he didn't leave until the supervisor got there.
Correct.
And there wasn't any problem getting out of the day room once you talked to the
Once the
supervisor.
supervisor was there, no.
Cody's been there for a period of time, correct?
I don't know the exact.
Well, probably longer than you've been there, right? And since that time, you've had interaction with him, with Cody? He's talked to you, he's complied.
Yes, sir.
You have good days?
Do I have good days?
Yeah. You got bad days?
Yes, sir.
Pass the witness. Thank you, Deputy.
No additional questions of this witness.
Is this man excused?
Please.
You are excused, sir. Thank you. Next, please.
Katie Droptini.
I do have a reference. The teacher, I think. Fantastic, thank you.
But state your name for the record.
Catherine Katie Drottini.
So the formal name is Catherine.
Yes.
Right.
But everybody calls me Katie.
Yes, ma'am. What do you do for a living?
So, I am a high school counselor. I've been doing that for 12 years, been in education for, what is it, 26 now? Used to be a teacher, so,
Okay, so you moved from teaching over to counseling.
yes.
And as a counselor, did you come into contact with Caitlin Nicole Stone?
I sure did.
When did you come into contact with her?
Her freshman year, I'm trying to think what year that would have been, but it was shortly before, she was murdered. I think, she was murdered a few months after she left high school.
Right, so the jury knows that the date of that incident was March 26, 2022. So that would be in the normal school year, that's going to be springtime, right?
So 2020, probably August, I guess, of 2021, right?
Right,
I'm an
so,
English teacher, not a math teacher, so.
right, if you start your school year in August of 21, you would go into the spring being 2022. And that school, want to make sure, what school was it that you were working at?
Fighter High School.
And she was a classmate there, correct? Or a
Correct.
student there? And do you remember what grade she was in?
She was a freshman.
And you remember her?
Oh, yeah, you can't forget her.
All right,
I'm
so
gonna try not to cry.
if you do, we have tissue, and everybody understands that we're all human. If you have reactions and you need a moment, just tell me, okay? You reached out to me about this young lady and how you knew her. I want you to share some of that with the jury. What was your impressions of this young lady whenever you dealt with her back in that school year?
Caitlin wanted somebody to love her and to take care of her.
You could sense that.
Oh, yeah, she didn't have anybody. She had a lot of people fail her in her life.
A bit of a broken home, right?
Correct. What I remember is an alcoholic grandma in particular, or it might have been, it was a caretaker at the time, who when we would call, if she ever got into any of her little shenanigans, because she did, but she was essentially raising herself. And we would call them and they would say not to call. Not
Wait. You call and they say, don't call?
Yeah, don't call us.
Well, don't run over that fact that fast. Does that happen a lot as a counselor when you're calling, trying to deal with an issue?
Mhm. Yeah, they didn't want to be bothered with her.
What'd that make you think?
I was heartbroken for her because she was amazing. She was intelligent, smarter than she did in school, because I think for her, her priorities were belonging, being needed, and
She wanted to sound like,
basic needs weren't being met, but for her. And when you have a student whose basic needs aren't being met, they're going to not be worried about algebra or English 1, or, they're going to be worried about belonging, fitting in, being taken care of. And that's where her priority was. She spent more time in my office than she did in class. Mainly, I think, because she liked spending time with all of us. We were her family.
the counselors?
The whole school.
Okay.
The counselors, the assistant principals. I was speaking to the registrar about her today. She bounced around, I think, and would visit with us and share things with us. And so in that short amount of time, she became one of my regulars. And that's the sense I got, that she just wanted a mama, or wanted to be loved and taken care of and to feel appreciated.
So every now and then we get a chance to make a difference in somebody's life. And it sounds like you tried to do that with Miss Caitlin. Am I reading that right?
Yes, I feel like I failed her.
You're not the one that committed this crime.
I know that one decision. I begged her not to leave school. She was a McKinney-Vento student. So what a McKinney-Vento student is a homeless student. They're
Okay.
not really homeless, but they're not living with their
Family?
guardian who should be taking care of them. And she would jump from house to house, kind of a thing. She was a couch jumper. So in order for them to get what they need, free lunches, when they get older, which she didn't get to do, but when they, become juniors and seniors, they get their testing paid for and things of that nature. It allows us to intervene to help them. But the unfortunate part of that is that it also allows them to make some of their own decisions because people aren't doing that for them.
Yes.
And so she decided that she wanted to go homeschool, which in education, a lot of times homeschool means dropping out.
Especially at this age, right?
Correct. And I begged her not to go. I begged her, told her, this isn't a good decision for you. You've got a lot going for you. You're a smart girl. But my biggest fear was that she was going to not graduate. It wasn't that she was going to be murdered.
Right. You were worried about something entirely different. And how long have you, I'm assuming you knew about this soon after it happened.
Yeah, we found out. And a lot of us were like, because we all talked about it. We were heartbroken and again, felt like we had failed her. I know that you can't hold them and I know you can't make their decisions for you, but could I have said something different? Because if she had still been in school with us, then she'd still be alive possibly.
Do you think she was taken advantage of here, man?
I think she was a victim. I think she was the perfect prey. You have a girl that needs somebody to feel loved. And I think she was perfect prey. I think that you have somebody that tells her what she wants to hear, or says you're going to take good care of them. If you're just a 16-year-old, you're going to believe that and hope maybe this time will be different because so many people have failed her. And I think that it left her open for that. Yeah.
Did you ever have any dealings with her father?
Nope.
You made a comment about a grandmother.
Being a grandmother, but I don't know if it was a foster. I just remember this grandmother stories that I heard were awful, and I do remember her telling me something about being held by the neck against a wall, and then like I said, if we called about her attendance or we called about any of that, literally she said, "Don't bother me. I can't do nothing with her." I think that's a quote.
Okay. All right. So we know she had some attendance issues because that's the call. Do you remember her grades?
They were not very good, I'm gonna be honest with you.
Okay.
But she didn't go to class a lot, we tried to keep her there, we tried to keep her in class. But she didn't come to school a lot, and when she like I said, was really just grades weren't important to her. It's the typical, if your needs aren't met, those kind of things are unimportant to you as a student. You want your needs met. And she would come for snacks. She would come for, go to the nurse's office for things that she needed. And, it wasn't important to her. So grades weren't great, I'm going to be honest with you. But she was smart.
How about her conduct?
the word I would use for her is feisty. She was a survivor. So she definitely was feisty. But not honestly, I don't remember that aspect of her. I do think that she may have had some problems at school as far as that goes. I know she didn't like being wronged, in her mind with that, whatever that would be. But I remember it more as being spirited. Like she would come to me and I would do the counselor lecture to her and she would apologize and say, I know, Mr. Octini, I'm trying to do better. You know, she wanted good for her. She wanted a future. And I just don't think she knew or had the capacity to figure out how to do that.
You're one of the first people that this jury's got to hear from that has an opportunity to describe this child. And you've given us some good background, but if you were, let's say somebody sees you after you leave the courtroom and they say, wait a minute, Mr. Cheney, can you please just tell me what this person was like? Well, how would you answer that question?
Feel like she had the capability to do so much in this world. And that she needed somebody to point her in the right direction. And she never had that. And so she was always trying to find a way to become better and to be better. And I know I kind of mentioned this when I contacted you, but like she held on to things, little things that you did. I gave her, sorry. I gave her my daughter's James Avery necklace that she wasn't wearing anymore because my daughter's Kelsey and she was Caitlin, and so they were both K's. And I gave her that necklace and she wore it every single day. And she would come in and she'd say, thank you, thank you, thank you, look, I've got it on. And she wore it all the time. And I remember when I found out she had been killed, hoping that she had it on her. Because I feel like nobody was there for her. And there's something of that necklace being around her neck that I could have been there with her if she had that on. I know that's kind of silly, or but she had the potential because she was strong. She was so strong that she could have done big things in this world.
Listening to you, I feel like she was just looking for acceptance in so many ways. Am I hearing that right?
Yes, completely. She wanted to be loved and she wanted to be taken care of. And I think when she found out she was pregnant or thought she was pregnant, that maybe her hope was, I'm building a family.
And you gather that just from what you knew of her?
Yeah, absolutely. Like, absolutely.
Giving you today a fair opportunity to be a voice for her.
I hope so. I appreciate you letting me do that because when we found out, and it was not just me, she affected a lot of the faculty at the high school. You know, and I know rationally, I wasn't the one that made these decisions, but you always hope that you can make a difference. And I don't know what I could have done, but I wish I could have done something different. So it was important to me when you asked me if I could do this. It was important to me to be here for her because I feel like this is the last thing I could do for her.
You've done well. Thank you. I'm going to pass the witness, Judge.
Good afternoon.
Good afternoon.
I didn't get or understand, when did she leave school?
So my estimation is that it was first semester, like at the end.
First semester of would have gone from the end of 21 to 22. So she didn't come back in January of 22.
My understanding, unless she enrolled in a homeschool, which I'll be honest with you, usually when the kiddos say I'm going homeschool, that pretty much means they're dropping out.
Well, you know, she didn't have a home to do that, right? And how long had you known her before she dropped out in January of 22?
Just that's first semester.
So from August to December. And
It's familiar with her too, because, you know, we have a lot of, you communicate with the junior high teachers and the, you know, so, but yes.
did she communicate with you after she left school in January of 22?
No, she did not.
Did you have access to her Facebook?
I did not have access to her Facebook.
The reason why I asked was because I guess she communicated just like everybody communicated Facebook.
No,
Yeah,
I
I was-
haven't heard of that.
There was testimony during trial that this is Cody Arnold. That Cody met her over at her grandparents' house or her grandfather's house. Would that been over in Vidor? Or do you know?
Honestly, I'm not 100% sure. I don't know if there was another side or anything, because and this could have been my interpretation, again, we didn't have a lot of contact with family. That it was just grandmother inviter, like
Okay.
that was the address, but I'm not 100% positive.
So grandfather could have been Jefferson
Other
County or
side.
something like that. So you don't know anything of that about whether or not she had talked about meeting someone that you really liked, dating,
Not after she left.
yeah, moving in together?
I don't know
Okay.
anything about that. I didn't know, you know, even where she was.
You talked about her possibly becoming pregnant or expecting. How did you find that out?
I think I didn't know about that until I read.
After the fact?
Yeah, like I read about,
Okay.
that they thought that she was pregnant or possibly.
And the reason why I asked that, ma'am, is that there was testimony that she was happy, she was posting stuff, pictures of onesie, you know, baby things and things like that. And I was just wondering whether or not you had seen it.
I know that.
Um, she really didn't have a chance, did she? No support.
Zero support. Like I said, at school, I feel like we were it. And I was worried about her when she left, but
And you don't know anything about the relationship between Cody and her and moving in and trying to start a family, or
I heard about Cody
was after the fact?
correct.
When did you reach out to Mr. Ham?
So essentially, I reached out to him. Was it Saturday? I think it was Saturday. I emailed him.
This past Saturday.
Correct. I have been watching the trial. I was actually planning on coming to the trial,
Okay.
and I discovered it was on Zoom. So I was on spring break, and I basically watched the entire time, and it just kind of. I wanted to thank. I mean, really, everybody in the justice system, because when you have somebody that you feel like nobody's fight for in life, to me, this whole process is a big deal for her.
Are you still at Vidor?
I am.
And I guess, have you learned or I mean, when I say learned, of when you see signs or what you just testified to now, saying, okay, maybe we need to do this or do that. I mean, it's a learning curve, isn't it?
Yeah, it sure is.
Uh,
I'm gonna be honest with you, an example for another girl of mine that was considering leaving, and I used Caitlin as an example. I'm like, I used to only worry about you not graduating, but there's a lot more to worry about.
Very good. Nice meeting you. Past witness, sir.
No further questions of this witness, Judge.
Is this lady excused?
Please.
Thank you, ma'am. You are excused.
Thank you. Thank you.
Next.
Savannah Horn. You watched me do this.
Yeah.
You want me to up and move the chair up?
I got it.
And it won't bite you. State your name for the record, please.
I'm Savannah Horn.
And What is your relationship to Caitlin Stone?
She's my cousin, but I have had custody of her and two brothers off and on over the years.
Well, I think you explained y'all are first cousins.
Yes, me and her mom, our first cousins, her biological mom.
What's her biological mom's name?
Tina,
Tina what?
it was still Stone when she passed away,
When did she pass away?
in 2011, I think.
And Caitlin would have been how old then?
Roughly around 7.
And not to get sensitive, I hate asking a woman her age, but what's the age difference between you and Caitlin Stone?
10 years.
Right,
Just 11.
right. So she was 16 when this happened. We know she was. You were 26 or 27 years old?
I was 25, almost 26.
All right. I got off track. So her mom passed in 2011, and Miss Caitlin would have been how old at that time?
7.
What's her dad's name?
Corey Stone,
Where's he?
prison, I believe.
In fact, in federal prison?
Yes, sir.
And in and out of that during her lifetime, right?
All throughout.
Now you said their lives. You helped me to understand that Caitlin's got some younger brothers, doesn't she?
It's too young.
And so let's go to the one, she would have been the oldest in that family?
Caitlin's the oldest. Then she had the middle boy's name is Hunter. He's 18 now. And the youngest is Caden, and he's 16 now.
And those boys were 4 years younger at the time in which this happened.
Yeah,
They would have been 14 and 12.
yes.
And I understand you actually have legal custody of these.
They both still. Yes.
Okay. Did you have legal custody of Caitlin at some point in time?
Yes, she lived with me a couple of months before she met Cody.
Right, so you don't know, but the jury just heard that she was going to Vidor High School. Is that true?
I'm the one that enrolled her in Vidor High School.
Okay. And the counselor said that she basically dropped out, chose homeschooling.
After she moved out of my house, she had dropped out once
Okay.
she had decided to move in with her grandpa.
She described calling somebody about this child's attendance and that person saying, "Don't bother me, I can't do anything with that kid."
I have no idea who that was.
That wasn't you, was it? Okay. You have an idea who that might have been?
There was a lady that her dad was dating before he went back to prison that she went and spent time with off and on. So it was probably her. I'm not sure of her name though.
Was she just bouncing between different places?
She was supposed to stay with Corey and he went back to prison and she told me she was moving in with her grandpa and apparently she was all over the place.
So does she, at that time, did she have two grandfathers?
I believe so, yes.
So you said she was gonna move in with her grandpa. Who is that person?
Sherman Sweat,
Where did that man live?
across the street from Cody's grandma. He also goes by Trellis. It's his middle name.
So he may have been called Trellis Sweat.
Yes, Trellis is his middle name.
Okay. And he lived in the Hampshire Finette area,
Yes.
not in Vidor.
He lives in Vidor currently though.
Okay.
He moved to Vidor.
A lot of people, a lot of different places.
Yes.
You shared with me that she called you something.
For a good portion of Caitlin Black, she called me.
It's okay. Jury knows everybody's human. And we all know we're talking about the death of someone there. And I did not intentionally ask you a question to make you cry in there.
Sorry.
But she called you a friend whenever she was dealing with you. What did she call you?
For a good portion of Caitlin's life, she called me mom.
In fact, you shared with me that you've got a tattoo that of a note she wrote you on your arm, right?
She wrote a note to me on one of our marker boards at home. I love you, mom. Have a good day. And she wrote her name under it. And I got it tattooed on my arm.
Did you do that after this incident?
Yes.
Go ahead and raise your arm and show the jury. That's exactly like the note that was written, right?
It's written in her hand.
Yes, ma'am. So she thought of you as her mom,
Yes, sir.
and she had lived at different times with you. Can you be a little bit more specific about when it was? Kind of give the jury some time frames. And the reason why I'm asking that is it really sounds like this girl was all over the place.
She moved in with us the first time in 2016,
Okay.
and she lived with us for 2 or 3 years. Not 100% on the time frame that they left.
Just best estimate is fine.
And she bounced around a lot. She was back and forth at my house, but didn't actually live with me for a while. Just whenever her dad would let me have her. And then in 2019, she moved back in with me until 2022, whenever she moved in with us.
We basically had her for that 3 years right before, and it sounds like anywhere from 2 to 3 years in the past too.
Yes.
And when I push about the mom label, you told me that you were present when some of the kids were born.
I was in the hospital room when all 3 of them were born.
And that's why you're close like this. And that's why again, I don't apologize. I don't mean to make you emotional. I'm just trying to make sure I understand it. If I understand, I'm hoping the jury's got a good picture of it. With that background, did she do anything to deserve what we've been talking about, ma'am?
No, sir.
Is this broken home, her bouncing all over the place, basically being what sounds like a couch surfer where she could go wherever she felt like she was accepted? That none of that really warrants somebody treating her like this, does it?
No.
Do you know the defendant, Cody Arnold?
I heard of Cody roughly a week or 2 before Caitlin died, but I was not given all of the information about Cody.
Seen you talking to his family. You've been very cordial with him, haven't you?
Yes, sir.
So we're all going through this loss together, so to speak, right?
I'm not the only person losing a child in this situation.
You understand and appreciate that, right? You still wish she was here though, don't you?
Yes.
One of the things you told me when I was interviewing you in anticipation of this testimony is that you've got to go home and talk to her brothers today. Tell the jury about that.
I worried all throughout the trial about what was gonna happen, because at the end of all of this, I have to go home and tell her brothers what happened. And I have to tell them what the decision was. And
So we start out with some good news right off the bat that he's been held accountable. Now you're waiting to see what the punishment is, right?
yes.
Is there anything more you think, you want the jury to know about Caitlin before they make that decision?
She's an amazing person. She was goofy and funny and kind. She was beautiful. She didn't deserve this.
How was her relationship with her brothers?
She loved her, but
Did she? We talk about her broken home. I'm assuming that same thing applies to Hunter and Caden, right?
yes,
Did she try to bridge the gap and be the mother to these children too?
she always was very protective of both of her brothers. And even after she moved out, she still called them all the time. No matter if they were separated or not, she always took care of her brothers.
Have you seen the impact her death has had on those two boys?
Yes.
Tell the jury about that.
The oldest Hunter, he is trying to become a firefighter now because he wants to be able to help people, and I have no idea where that came from. But he has no social life. He never leaves the house. Neither one of my older two leave the house. They don't hang out with friends. They're homebodies.
Just kind of isolated themselves.
Yeah.
Think it's fear?
I think they're finally comfortable where they're at home.
You just want to be there. Fair enough. Thank you, ma'am. As witness, you need to wait. The defense may have a question.
Good afternoon again.
Hello.
You talked, which one?
Both of them?
Both of them. And y'all were sharing photographs and talking, right?
Yes.
Both a loss.
Yes.
It's terrible, isn't it? Tell me a little bit about Grandpa. Why did she decide to leave you and go over to Grandpa's house?
Originally, it wasn't to go live with her grandpa. When she first left my house, it was because her dad had gotten out of prison. She wanted to go and live with him.
She wanted to go where? I'm sorry, man.
Sorry, she wanted to go and live with her dad,
Okay,
and he ended up going back to prison. And she moved in with her grandpa after he went back to prison.
so she was with you, Dad got out or whatever, and then she wanted to go back and live with Dad. And then Dad got in trouble again and had to go back, right?
Yes.
And why didn't she come back to you?
I don't know.
Okay,
Her grandpa was called.
the brothers were there, right? Her brothers
No,
were
I did
there.
not have that yet.
Okay, now, when was this?
In
Just roughly, I mean,
2022.
okay,
The same.
well, now, this happened in March of 22,
I didn't get them until the end of 2022.
the end, so after this happened?
Yes.
Okay, well, I'm talking now about before.
They were in a foster home in Lubbock.
Okay, well, that puts a little bit of a different spin on it in the sense of, and who was she with when she went to Vida High School? Who was she living with?
Me.
Okay, you live in Orange County, right?
Yes.
Okay. And there was testimony that she left at the end of 21, the school year of 21, 2021.
Yes.
Okay. And was she living with you at the time?
Yes.
Okay. And I guess what I was trying to get to is that from there, she left school in starting January of 22. Why, you said that she wanted to go back to live with Dad. Did she go back and live with Dad then?
Yes.
Okay. So that might have been the person that school was calling when she left you and moved back with dad in January of 22. Does that sound about right?
He said it was a woman, so I assumed it was the girlfriend that lived with
Okay.
her.
Well, it's dad's house, right?
Yes.
And do you know when she moved over to her grandfather's house?
I'm assuming whenever her dad went back to prison. I wasn't told about her moving in with him until after the fact that he had gone back to prison.
Okay, so you didn't have any idea that
Yeah.
what she, okay. If you were around here, you realized that Caitlin and Cody had moved in together.
I did not.
You did?
Whenever I would talk to Caitlin on the phone, she would tell me that she still lived at her grandpa's house.
Okay. Were you on Facebook with her?
Sometimes it was Facebook, sometimes it was her regular phone.
Okay. There was testimony that that was basically her mode of communicating with people. Did you know that somewhere around this time that she thought she was expecting?
No.
Didn't
She
know
didn't
that?
tell me.
She didn't tell you that at all? Because there was things that said that she posted and with like baby's clothes and happy and just communications, Cody, everybody of they were having a child and a family and stuff like that. But you didn't know anything about that.
I didn't.
Okay. What do you know about the grandfather?
He's been a part of my life, my entire life.
A good person?
Yeah,
I mean, somebody that works hard and I mean, somebody that you trust.
yes.
And the reason why, and I mentioned, because we're trying now to find out about Caitlin.
I understand.
And why do you think that he would have allowed Caitlin and Cody to start dating and then ultimately allowing Caitlin to move in with Cody?
I have no idea.
Okay. And you realize Caitlin was 16,
Yes,
Cody was 21.
I didn't know it at the time, but I
Yeah.
know now.
And that they communicated or saw each other over at your grandfather's house. And then ultimately started dating and I guess moving in. And we don't know whether it's how long they were together. But your grandfather was I mean, he didn't shun her away,
No.
like, you're in trouble, get out of here. He
If anything, he would have called me.
would have called you, but
Yeah.
he said, come on over here, I'll take care of
Yes.
you. Okay. Again, ma'am, I'm sorry for your loss.
Thank you.
Okay. Pass witness, Judge.
Sid,
No additional questions of this witness,
is this lady excused?
please, Judge.
You are excused, ma'am. Next, please.
State of Texas rests.